5 seconds to go. Start. Having heard the learned counsel for the parties, the court finds that the directions given by the learned single judge is in consonance with the policy framed by the Mandi Smiti. A perusal of the policy indicates that priority was to be given to those traders who had no shops allotted to them and who were paying the Mandi fee. Clause 1 of the scheme indicates that a list would be prepared from those eligible traders who had no shop allotted in their name and who were paying Mandi fee. Clause 1 indicated that the list would be prepared in the descending order, namely, that a trader who was paying the highest fee would be placed at serial number 1 and a person paying a lower Mandi fee would come at serial number 2 and so forth. In the light of this provision, the learned single judge found that there were 147 applicants and that the total number of shops constructed were 74 in number. The learned single judge accordingly directed that the Mandi Smiti would prepare a list of those applicants who do not have a shop in the market yard, either in the individual name or even as a partner of a firm. Such direction, in our view, is in consonance with the scheme framed by the Mandi Smiti, namely that the shops would be allotted to those traders who do not have a shop. The contention of the learned counsel for the appellant in Special Appeal number 272 of 2009 is consequently bereft of merit. At this stage, the contention of the learned counsel for the appellant that the Mandi Smiti has itself certified that the appellant do not have a shop and have arbitrarily been ousted from the list and therefore a direction should be issued is also bereft of merit. Such information was not before the learned single judge, nor such documents could be considered in the appeal. The submission of the learned counsel for the appellant is that there was no error apparent on the face of the record and consequently the order could not be reviewed by the learned single judge is patently bereft of merit. He further submits that earlier order directing the shops to be allocated by draw of lots was in consonance with clause 6 of the scheme is wholly erroneous and misconceived. From a combined reading of clauses 1 and 6 of the scheme, it is clear that the list of eligible candidates who do not have a shop in the market yard was to be prepared in the descending order on the basis of the market fee payable by such applicants. The court clarified the scheme by holding that where the number of applicants are less than or equal than the number of shops, then in such an eventuality the shops would be allocated as per their names in the list and that the use of lottery will not be for allocation of the shops but only for the choice of shops. Stop.